Hello, my name is Brandan Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. In this video, I want to talk to you a little bit about doing things the right way whenever your lawyer is working on your case. Now, there's the easy way to do things and there's the right way to do things in everything in life. This is no more important than in your criminal case. I'm going to give you an example of how doing things the right way versus doing things the easy way can give your client a lot better outcome in his case or her case. Now, at the outset of any criminal case, your criminal defense lawyer is going to want to get the discovery in the case. They're going to want to get the police reports, statements, videos, anything that's relevant to your case, anything that tends to prove that you did do something or didn't do things. And they're going to want to look at that before they can make a case evaluation and kind of guide you in how to work out your case. This is one of the slip-ups that I see a lot of attorneys make. There's an easy way to get discovery, and then there's the right way to get discovery. Now, the easy way to get discovery is to go to the local police station or go to the district attorney's office and fill out a form. And that form will say, hey, I'm your lawyer, I want to get discovery on this case, I'll pay a small fee for it, please give me everything. Submit that to the court, and probably 95 out of 100 times you're going to get everything that the district attorney or that the city has to offer on that case. No one's going to deliberately try to hide the ball or anything like that. That's the easy way of doing it, and for most cases, that'll be just fine. There's a right way of doing it also. How you do that is file a motion for discovery and inspection. Now, this is a document that your lawyer will draft and file with the court, basically lining out every single thing that they think that they're entitled to. And it'll put the district attorney's office or the city on notice saying, hey, I want these things as part of the representation of my client, I'm due these things. Now, probably 95 times out of 100, the district attorney's office won't even look at that. Or the city won't even look at that. They won't respond to it. They won't object to it. They'll just see it and say, oh, that lawyer wants discovery. Now, again, 95 times out of 100, this will never be an issue. You're going to get the same exact evidence that you got by filing the motion for discovery as you would by simply filling out the form at the court. But in the instances in which you don't get discovery, that's when it's important. If you're ever in court, and I've had this happen, you get in court and you're getting ready for trial, you're at trial, you're doing some sort of evidentiary hearing, and the prosecutor pulls out something you don't have. Or the officer starts talking about something you haven't seen. That's not supposed to happen. Your lawyer is supposed to get everything beforehand so that they can evaluate your case and see what the best way to proceed. When this happens though, you want to have your motion for discovery and inspection to fall back on. Because standing up and saying, Judge, I object to this piece of evidence, Judge, this piece of evidence wasn't disclosed to me during discovery, doesn't get you very far if you haven't got a document on file saying you specifically requested it. You can't go back and show the judge a form and say, Judge, I filled out this form, I should have gotten everything. You can go back and say, Judge, look at document number 15 filed in this case. I specifically requested this on this date, and the prosecutor hasn't disclosed it to me. You can see in that instance how the judge is going to probably rule in your favor on that case, because he's going to look, or she's going to look at that document, say, prosecutor, this piece of information was requested by Mr. Davies, and why didn't you provide it to him? Then if they haven't responded to it, then they can't even allege that they told you they don't have to provide it to you. Not to get too much in the weeds on this, but this can be the difference between winning your case and losing your case. This can be the difference between having your case dismissed right then and having your case proceed. This is the difference between doing it the right way and doing it the easy way. If you have questions and you're talking to your lawyer, if you're interviewing lawyers, ask how they do things. Ask if they do things the easy way or they do things the right way. Because you may be one of the 5 out of 100 that's going to come into play on. And you want to be able to take advantage of the other side's mistake in your lawyer's hard work. If you have any questions about criminal defense, if you have any questions about trial, feel free to contact my office at 913-451-9500. Thank you.